Now, this afternoon on The Legal Hour, we unpack one of the most important and often emotional aspects of family law, that is parental rights and also responsibilities regarding children after separation or divorce. Now, many parents are unsure about issues such as custody, care, contact, rights and guardianship, and also how South African courts determine what is in the best interest of the child. Now, to guide us through the legal framework and common misconceptions, we are very pleased to be joined by Advocate Mohammed Abduroaf, Advocate of the High Court of South Africa and also family law expert. Assalamu alaikum, shukran so much for joining me.
Wa alaikum salam and shukran for having me again.
It's always a pleasure speaking to you, Advocate. Now, in South African law, right, what is the difference between custody, as people commonly understand it, and the legal concept of care, contact or guardianship?
To simplify it, the word care is quite a new concept we brought into via the Children's Act maybe about 20 years ago. Mm-hmm. We used to use the word custody. But custody and care, you can say, similar. Mm-hmm. I believe that the reason why they use the word care, it becomes more holistic, more in a loving fashion. Where custody is more like I just do what I have to do. But the concept basically relates to the caring of a child. A child who has custody under parent, that parent will have to provide the child with a home, attend to his schooling, take him to school, and the day-to-day affairs of a child. That's basically the custody of the child. And you have care, so you do those type of things. Then the other concept comes to mind is the one of contact. And back in the day, they used to use the word visitation. So that's basically the similar as well. One parent would usually have custody or care over the child, where the child will live with the parent during the week. That parent will attend to homework, take the child to school, and so on. And the other parent will have now contact or visitation on the weekends. Or possibly you can even argue that they have now care over the child over the weekends. So every second weekend from a Friday till a Sunday, that parent will now have care over the child. But care and custody is the issue concerning looking after the child. And visitation is seeing the child for a short period of time, and contact as well. But more importantly is the other concept of guardianship. So many people do not understand what is meant by guardianship, or they categorize guardianship and custody as a one thing. So guardianship basically means the legal aspects of a child's life.
Okay.
For example, giving consent for the child to leave the country. Giving consent for the child to apply for a passport, enrollment into schools. You know, when a child wants to go on an excursion, they say a guardian must sign here. So it deals basically with the legal aspects of a child. If a child wants to get married sooner. Therefore, when it comes to guardianship and custody, they are two separate things. Because you can have a scenario where a parent has no rights of custody, contact or visitation over a child, but that parent has guardianship rights over the child. So he cannot see the child, or she cannot see the child ever, but should the child apply for a passport, that parent must be consulted.
Okay.
And obviously with care comes the issue concerning maintenance as well and so on. But that's broadly the concepts that apply to children.
Now, when parents separate or divorce, how do courts decide where a child should primarily reside, and also what factors are considered in determining the child's best interest?
So ideally, we would like to have a situation where the parents live next to each other and the child can jump from one home to another home. That's ideal, because that was the situation when the parties were living together, if that is such a scenario. Now, in South African law, if parties were married to each other, now we apply now to fathers, because mothers automatically have guardianship rights and custody rights over the child. That's by default. But with regarding a father, if he was married to the mother, then automatically he has co-guardianship rights and co-care rights over the child with the mother. But if he was not married to the mother, my apologies. Now that there can be many examples of that. It could be, for lack of a better way of saying it, a one-night stand, or they met each other, they dated for a few days, a few weeks, and fell pregnant, and the father went missing. That's the reality of today. So here we have a situation where a father, he is the father of the child, but he was not involved in the child's life for the last 10 years. So he can't pitch up and say, I'm the biological father, I now want to have contact with my child. But the child said, I don't know who you are. So in South African law, if you are married to the mother, automatically you are co-holder of parental responsibilities and rights. of guardianship, care, contact, and so on. If you were not married to the mother, but you were involved in the child's life, paid maintenance, took the child to school, contact with the child, and you were there, then you acquire those rights. That's very important to note where that is concerned. But the law says we apply the principle of what is in the child's best interest. That's very important to note. So if the child would be better cared for by the father, then that would have to apply. So you have to look at the scenario. We look at the child's age of development, needs of the child, and so on. Which parent can better care for the child? And if the mother is more available, the child is more connected to that parent. The child wants to be with that parent, and the parent has the capabilities historically for caring for the child. The court will most probably give the child primarily to the mother. So she will have primary care over the child, primary care.
Okay.
And in that specific scenario, the father might have contact with the child every second weekend, but also half the school holidays. So a lot of factors come into operation, because if the mother lives close to the school, it makes logical sense for the child to live with the mom. But if the mother lives close to the school, but the mother is the one traveling the world every single day, she's a very busy lady. And it makes more sense for the child to live with the dad and then enroll the child into a school closer to the dad.
And that would be the best interest.
That would be the best interest under these circumstances. So you have to look at everything and determine what is best for the specific child and the specific couple.
And this is basically what the courts decide.
So the court will make a ruling on that.
Okay.
But the court would require assistance and advice of experts. Now, a judge or a magistrate in the children's court or in a divorce court will never meet face-to-face with a child. They don't do that. And it's very rare where parties are legally represented that a magistrate or presiding officer will speak to the parents in court and make a determination based upon what they say. This is where the Office of the Family Advocate comes in, a judicially appointed body in terms of an act of parliament, appointed that office to deal with matters concerning children in care and contact disputes and in divorce disputes as such. And then we also have social workers that are connected to the court, social welfare department, and so on. So these are social workers or psychologists and psychiatrists that have the expertise to investigate and communicate with the parents and the child, and they can provide the court with some advice as to what they believe is in the child's best interest. So you can either go the free route, the public route, like the family advocate and social workers and so on, or you can appoint your own psychiatrist, your own psychologist that can do an investigation, and they will have to advise the court, in our opinion, based upon all these variety of factors. We believe it will be best for the family to share the contact of the child and care of the child, A, B, C, and D. Or they might say, we believe that it's best for the child to be with one parent 1 week and another parent the other week. Or they might say that parent should not have contact at all.
But now, wouldn't it also mean that sometimes I will say whatever is in my best interest in terms of having the child was in my care? And sometimes this could not be the case, isn't it?
Yes, everybody puts forth their best foot.
Absolutely.
It happens so often. And that's why the court wants these external people. Because you can go to a very good lawyer or an advocate or an attorney, and he or she can draft very good documents saying that you are the most perfect parent and put really nice things over there and say a lot of bad things about the other parent. They do that. They often do that. And then the other lawyer on the other side will do exactly the same, but say bad things about the first parent. The court is in no better position to make a determination. All that the court knows is that both parents want to have care or contact with the child and that they are miles apart. That's where the court now asks for the assistance of external experts to advise them. So many times the courts don't really look at the affidavits of the parties. The courts looks at the reports of the experts and they make their order or judgment based upon that.
Now, today we are discussing one of the most significant and often emotionally challenging areas of family law, that is parental rights and responsibilities following separation or divorce. Now, when parents part ways, questions often arise about care, about contact, arrangements, guardianship, and decision-making authority, and what rights and responsibilities each parent has towards their children. There are also many misconceptions about the concept of custody, and also how courts determine what arrangements will best serve a child's needs. And of course, in studio we do have Advocate Mohammed Abduroaf, Advocate of the High Court of South Africa, and also a family law expert. A reminder that our lines are open in 0216991786. You can also send your questions or comments to 0786 10 11 12 if you wish to be part of our conversation this afternoon. Now, Advocate, does one parent automatically have maybe more rights over the other, or do both parents generally retain parental rights and responsibilities after separation?
So it depends upon if they were married. If they were married, automatically both parties have equal rights over the child. But you can't cut the child in half. So now we have to find a solution. The same way me and you might purchase a car together, but now you move to that area, I move to this area, and we have to now figure out a way how to resolve this. You can use a car in the day, I can use a car in the evening, or the weekends, and whatever the case may be. The same thing regarding a child. And various circumstances, the car might have to be serviced on a Sunday. Then we have to now decide what happens on a Sunday. So that's how it applies regarding kids. If the father here does not have those parental responsibilities and rights, then there has to be an inquiry as to determine whether or not he acquired them. My experience over almost 25 years, if a father comes out of the woodwork, even 10 years, and I wouldn't say after 15 years, that's a bit too late, but should the father maybe come after 10 years out of the woodwork, and now he says, I now want to have contact with my child, although I never had it for the last 15 years or 10 years because I wasn't interested, the court will first have to determine, is it in the child's best interest for this person now to come into this child's life? That's very important for the court now to determine. And the court will determine that after the expert have consulted with the child. Because I done matters, quite a few of them, where the child says, I don't know that man, I don't want to know that man. This is my daddy, my stepdad, but I don't see him as my stepdad, I see him as my father. And I do not want to know this next person, whoever that person is. And then the court will have to respect that. Obviously, it depends on the age of the child. If the child is very young, let's say 7 or 8, the court will technically, force contact. In a professional way, but at some point it will happen. Should the child be maybe 15 years old and very studious and involved in schoolwork, the court will say, okay, we cannot now uproot the child's life. She's in grade 10, she's now busy with the schoolwork at A, B, C, and D. Now this man wants to be involved in the child's life. Let the child live a life. We can maybe relook it once a year and re-ask her, but we're not forcing, we're not uprooting the child's life. So it depends on those specific circumstances. Therefore, if you want to be involved in a child's life, do it as soon as possible as a father.
But I would imagine that even if the father comes back after how many years, that because he's biological father, you would think that contact is necessary or like it should happen.
But there are a lot of nuances involved here because remember, the mother might not like this guy as well. And the stepdad, who the child is living with, might also not like the father. I'm using that as an example. I believe it's in the child's best interest ultimately to know who the biological father is and to build a relationship. But it also depends who the biological father is. He might have come out of prison. He might have a very shady past. And now you want to expose a certain type of child to that type of person. The knowledge of the biological father, I believe that is important. That needs to be known to the child. But an analysis must be made. Is it in the child's best interest to uproot and bring this person into the equation, into this life of the child at a specific stage? 9 out of 10 times it will happen. But it will not happen as the father would want it maybe to be. Now, many fathers, they come and they were not involved with the child's life for many years. Then all of a sudden say, I would like my daughter to have overnight contact with me now with my family in that specific area. And this is what happens. And the court will have to now deal with these specific scenarios. And the child does not want to. He must meet this person, let alone overnight with his or her family. Now, these are the evils that come about when people start separating. And if I may, sometimes what happens is a mother hides the child away from the father for years, or make it very difficult. And when finally this matter actually comes to fore, and then the mother doesn't know how to deal with this, because one scenario might be the child now wants to be with the father, but the mother doesn't want that. And these are the complications that comes about.
Radio 786 100.4 FM, and that, of course, Advocate Mohammed Abduroaf, Advocate of the High Court of South Africa and also family law expert. And today we are really unpacking one of the most important and often emotional aspects of family law, and that is, of course, parental rights and responsibilities regarding children after separation or divorce. A reminder that you can too be part of the conversation if you have any questions. 0786 10 11 12. Now, what options are available when parents cannot agree on contact arrangement or schooling or a relocation or maybe any major decision that involves the child?
Now, there are certain things that the law expects the parties to be able to resolve on their own, like contact arrangement and so on. Now, there is a provision in the Children's Act, Section 33. It says specifically, if the parties cannot agree on parental responsibility and rights, they should first try to mediate those issues. Go to a third party, a social worker, a psychologist, an attorney, maybe an advocate, and so on. Try to mediate it before approaching the court. Now, many courts are implementing that section or provision. They try to resolve it via mediation, but some do not. But it's also important to note that certain matters might be urgent and there's no time for mediation. For example, let's say the mother says, you cannot see the child ever, then what's the purpose of mediation? She took the child away from the dad, whatever the facts are. But there are certain things that a father can do. I would also advise, when you're dealing with a child, it's not about my rights. It doesn't work that way. We're dealing with a human being and who has feelings, emotions, and so on. And we're dealing with another dynamic as well. Because we have a scenario where the father, I'm using the father as an example because that's generally the scenario. But I apologize, I don't want to offend any fathers out there. But you have a stepdad or the mother, she spent her last cent. She never ever went out to the movies for the last 5 years because she's caring for the child. Money is super scarce, but she made it happen. She looked for the father was missing, couldn't be found. She tried to get maintenance from him, he doesn't want to pay anything, a different scenario, whatever the case may be. But now he wants to be involved in the child's life. A lot of emotions that applies. But the first step is try to mediate the matter. If that doesn't work, then I advise the fathers to go to the children's court. There's no cost involved. And they can call the mother in and try to resolve the matter. They can obtain a social worker, the court can instruct a social worker, and the social worker will now get involved. That's the one aspect. You can also instruct an attorney or an advocate to assist you on those specific matters in the children's court. Then there's a different way of dealing with the matter, is to approach the High Court. An advocate will have to be instructed or appointed in the matter, and they can launch that application in the High Court. So the difference between a High Court care and contact matter and a children's court care and contact matter, basically the children's court is done orally, meaning that the parties will speak. The court will consult or engage with the mother, engage with the father. That's what happens in the children's court. In the High Court, everything is done on affidavit, generally, whereby the applicant will draft an affidavit, the respondent will provide an affidavit, and so on. So those are the difference. But obviously, High Court, you have advocates, attorneys, can be very expensive, whereby the children's court is made for laypersons. It's made for people without lawyers.
Okay. Now, we do have a few comments from our listeners. One asks, if there's a third party involved, can you, as the mother, request that the person not be involved in my children's life? And I'm assuming this is probably the partner of the father also. And then there's one more that reads, how do we prove to the court parental alienation?
So regarding the first question, you can ask. Do not allow Miss A to have be in my presence of my child when you are exercising contact. Or when my daughter is overnighting by you, do not have your boyfriend be in the presence. You can ask. But if they decide not to see to that request, there's not much you can do under those circumstances, because that is a time with the one parent. There's not much you can do. If you have a problem with the one parent not agreeing with your request, then unfortunately you'll have to go to court. But I have not seen in my practice now for all these years that a court really forces a third party not to be present when contact is being exercised.
So the condition is a little bit
It's a bit too much. Because the third is usually on jealousy. Unless you tell me now that the third party is a sexual offender, is somebody that assaults a child, that's a different scenario. But then you have other mechanisms like the domestic violence court, getting protection and so on. But I haven't, and I've been very busy over the last 20 odd years, and I never really saw a court limiting another party, because then today it will be Miss A, and then they break up, and then another Miss B comes in. Who will ever have contact with a child? This is part of life. So that's the first issue. The issue concerning parental alienation, you need to get a professional person on board. Because not very few people are trained to determine is it parental alienation or not. Because we have to investigate the matter. Because usually it will be now when dad phones, the mother might, for example, your daddy's on the phone, talk quickly to him, I don't want to speak to him. Now that can also be a form of parental alienation indirectly, because now it makes the child not want to speak to dad and speak to dad quickly. Or saying, speak quickly, we go to McDonald's in 10 minutes time. Although the daddy is entitled to have 1 hour of video contact with his daughter, whatever the case may be. Or say, you want to go to daddy this weekend, but it's Susie's birthday party this weekend. Okay, let me cancel. No, mommy, tell daddy, I don't have contact with daddy this weekend. Because life is good. And the opposite also applies. So it's difficult to prove. You have to get a professional person on board, a psychologist, someone who has experience in the aspect of parental alienation. Because sometimes a parent tries it and it doesn't work. So there isn't really parental alienation. But the sad part is, if you have a scenario whereby the child says, I do not want to see that parent ever again. Whether or not it is to do parental alienation, I wouldn't know. Someone has to consult with that child and speak to the child and determine what are the reasons for that. It could be because maybe mom is a bad mom, in the sense of dad is now alienating the child from mom, and mom is very strict with the child when the child is in mom's care, and therefore the child does not want to go to mom. That could be the legitimate reason, or there could be other reasons as well.
That's 100.4 FM. This is Radio 786. We have Advocate Mohammed Abduroaf in studio with us, and of course we are discussing, and really he's helping us navigate the legal framework and providing clarity on these important issues. And that of course is what happens when parents are separated and there's children obviously involved. 0786 10 11 12 or 0216 999 1786. Now, how does the family advocate assist the court in matters involving children, and what role does the child's own wishes play in these proceedings?
So the Office of the Family Advocate, the person in charge will be the advocate.
Okay.
It's someone who's trained in law with an LLB degree, admitted as an advocate of the High Court of South Africa. Basically a lawyer, basically. Now, that specific person, with additional training, of course, will firstly meet with the parties. And advise them what their role is, that they are not representing either party or they're not representing anybody, the child. They're here to find out the truth and report back to the court. And at their first meeting, usually they try to resolve issues, because sometimes issues are quickly resolved. But if the issues cannot be resolved at that specific first meeting, now an investigation has to take place. Now, the Office of the Family Advocate in Cape Town, they appoint social workers. They appoint, maybe one family advocate with maybe 2-3 social workers underneath him, depending upon the ratio. And that social worker will now look through the court documentation that's presented, what mom says, what dad says. He or she will now consult with both parents, either individually or separately, depending upon what the issues are. Might consult with the child, with the parent or not. What they many times do is, depending upon the facts, is go to the parents' homes and see if the house is good or not. Over the years, I've done matters whereby the parents do not live in the best of areas, but the family advocate never had a problem with that. As long as the house is clean, they're okay with that. So you don't have to be shy about that. Even if 10 people are living in a house, but it's decent, it's private, and they're okay with that. It must be clean and place for the child to be. Obviously, there are scenarios whereby there are concerns, where strange men and people walking in the house, brothels and so on. That happens as well. So the family advocate will determine that. Look at the house, look at the child, see how the parents communicate with the child, and so on. They will also speak to collaterals. That's collaterals, meaning maybe the school teacher, uncle, aunt, maybe significant other. a new partner, spouse, and so on. And after they've done all of that, they will now provide a report. And the report will have certain conclusions in it. They say, we've done the following, these are the issues involved, and we conclude that it will be in the child's best interest that the following arrangements take place. For example, the child be in the dad's primary care from Monday to Friday, and every second weekend the child will be with mom from Friday 5 o'clock until Sunday 5 o'clock. However, school holidays will be cut in half. One half for the dad and one half for the mom. Day, Christmas Day, depending upon the facts and circumstances, will be dealt with as follows. So they will provide that specific recommendations. The family advocate will then look at the recommendations of the social worker, and he or she will now comment on that. If he has a problem with it, he might send the social worker back and saying, please, what do you mean by this? Maybe change your report. But out of all these years, I never yet saw the family advocate disagree with the social worker, because I'm certain they work with this file together. They work with it together. And that report or that recommendation will be given to the court. The court will look at it, and the court will now determine the matter based upon that.
Now, here's one more question or comment. It says that I'm reaching out for advice regarding a painful family situation. My daughter passed away 1.5 years ago, and when she was alive, she and her son lived with us, and we were his primary support, as his father was rarely present and barely provided for his son financially. Since my daughter's passing, the father's family took custody, and the paternal grandfather now controls all access to the child. We are almost entirely shut out, and any supervised visits are strictly on his terms. We just want to be a loving, have a loving presence in our grandson's life and ensure he remembers his mother. How can we navigate this controlling dynamic to secure consistent, healthy visitations? Does advocate have experience with grandparents' rights or advice on how to handle this kind of alienation, and are they allowed to do this?
So this is something which I dealt with quite often. Either the grandparents that comes to me or the aunt comes to me. Could be a friend that also comes to me. But it's usually the aunt or the grandparents. They come to me because either the sister passed away or the child passed away, the daughter passed away. It's usually the daughter that passed away. In South African law, only two people have parental responsibilities and rights over a child. That's mom and dad. That's it. So in this specific scenario, because the daughter passed away, the moment the daughter passed away, automatically the father had sole parental responsibilities and rights over the child. Grandparents are grandparents. They're not here to look after kids, and they had the chance with their kids. But the beautiful thing is, in terms of Section 24 and 25 of the Children's Act, it is possible for third parties, interested third parties, like grandparents, like aunts, to be all ex-spouses. Because let's say you have a stepchild and now your spouse passed away, and now the child must go back to the other parent. People that have an interest in the well-being and care of the child can be assigned parental responsibilities and rights.
By the court.
By the court. That is the Section 24 for care and contact, and Section 25 for guardianship rights, or might be 23, 24, 25. So that is possible. Now, the same principles applies. What is in the child's best interest? And I am yet to see any court of law saying it's not in the child's best interest to have contact with the grandparents. I've seen it so many times. So what needs to take place under these circumstances are that these maternal grandparents whose daughter passed away should either approach a lawyer, or they can go to the children's court and ask the court for them now to be assigned parental responsibilities and rights of contact with a child. I don't think they want a child to stay by them. And there is a biological father, so he must deal with that. And more than likely the court will make such an order. There's nothing stopping him from doing so. That the grandparents' house is normal, as it always was when the daughter was there, and so on. So that's what they must do. Assignment of parental responsibilities and rights.
Okay, 0786 10 11 12. That is how you can be part of our conversation. One more question that came through, Advocate. It says, my ex-husband went to children's court to get a court order to prevent my current husband from being in the presence of my 2 kids. When my son turns 18 years old, does this automatically fall away? The second question is, if my son decides to have contact with his stepfather, how do I as a mother change this?
Now, when a child turns 18 years old, all parental responsibilities and rights other than maintenance falls away. Meaning that if there's a court order that says that custody or care is granted to the mom, for argument's sake, and the child turns 18 today, the child can now decide, I'm living with my dad. Just like that. You're no longer a child, you're an adult. So that's just how the law works. However, maintenance provision still remains. The parents still have a legal obligation to maintain their child, their adult child, until the child is self-supporting. Even if the maintenance order says maintenance is only applicable until the child turns 18 years old, that order might fall away. But the child can still go back to the maintenance court and ask them to make a new order because he or she is not yet self-supporting.
Okay.
If the facts have changed, and I'm looking and I'm reading in between the lines, but it seems to me that at some point the child did not want to have contact, but now the child wants to have contact with the biological father because now circumstances have changed. There's now material change in circumstances. That parent should now approach that court that granted that order and say, now the child wants to have contact, please vary the order.
0786 10 11 12. We continue with more questions. What are some of the most common misconceptions parents have about custody and also access rights in South Africa?
And you'll agree with me, is that mothers have sole custody over the child. That's standard. The moment the child pops up, the mother believes I'm the only one with
and I have the right to say, you know what, you can't access the child.
Standard. That's the most basic misconception that we have, and it's not so. I agree with 100%. If once a child comes out medical, obviously the one that has the most rights over the child at that moment is the mom, because the child might be breastfeeding and care for the child. They can't go take the child away, but that becomes less and less as the father can now be involved in the child's life. So that's the main misconception over there. The other misconception which arises is that fathers believe that they can never get custody over the kids or primary care over the kids. That's an old one that had to be kicked out of the window about maybe 10, 15 years ago, because it happens quite often now.
Where the father is the sole.
No difference. No difference. The family advocate makes an inquiry, they look at, but there's no difference between mom and dad. The only difference is for the first 6 months or a year, the mom was the prime attachment to the child because of the age of the child. But beyond that, dad took the child to school every morning. Dad took the child, done her homework. Mom was working. She was doing good stuff in the house. Don't get me wrong. But you cannot say which parent was more involved materially. Both of them was just as well involved. So that's another misconception, that dads cannot get primary care over the kids. Another misconception, or maybe something that people need to also look at, and part of your the title of this discussion is that, do I require the father's consent or the mother's consent to take the child out of the country? So because he or she is not on the birth certificate, that's it. So in South African law, the only difference with having your name on the birth certificate, it assists in determining if you have parental responsibilities and rights, if you're not married to the mother.
Okay.
So if your name is on the birth certificate, automatically you have parental responsibilities and rights. But if your name is not on the birth certificate and the parent wants to leave the country, but you are involved in the child's life, you are a guardian of the child because you're involved in the child's life, you pay maintenance, that parent must still get your consent to leave the country, to apply for a passport and so on. So those are the general bigger misconceptions we have in family law. Now,
what if we decide, okay, we want to divorce, right? But there's nothing wrong with... So and there's a scenario where obviously they need to now determine what is in the best interest of the child. Does it sometimes become difficult for the court to decide that when they look at the lives of both the parent, the father or the mother on its own?
And you're right on that aspect over there. But maybe I can assist you one step further. Sometimes you have a scenario whereby one party might say we want 50-50. 1 week with you and 1 week with me. That's more like a middle ground shared care scenario over there. But if you have a situation whereby the father says, I want to have primary care over the child. Monday to Friday with me. And the mother says, no, I want to have Monday to Friday with me. It's a very difficult one for the family advocate to determine because it's not necessarily financial.
Yeah.
It has more to, then you have to look at other dynamics like siblings being together. Do we want to break apart siblings? Because maybe the elder two siblings says, no, I want to be with mom because we love mom. But then the younger two siblings say, no, I want to be with dad. So these are all the things that we have to now consider and determine what is best for the kids. Because the only scenario here in these circumstances would be one must have primary care and one must have secondary care over the kids. So it can become very, very complicated, but an answer must be made. The court cannot make 50-50 because it's impractical. And we cannot say the girls go with the mom and the boys go with the dad. That's also not in the kids' best interest. So we have to find out good, very creative solutions under these circumstances. But on that point, we have now video contact, we have WhatsApp video. So keeping in contact with the kids are generally much more easier than back in the day.
Just one other thing I thought of whilst you were answering. Does the court ever consider emotional and emotional support? Because sometimes we only look at financial support and whether the father or the mother is able to do that. But I think there's a huge amount of support when it comes to the child's emotions as well. Is that one of the things that is considered when determining?
Yes, in terms of the Children's Act, the court has to consider the child's emotional connection with the parent. That's very psychological, emotional, all those things. The court will have to consider that as well. So you're 100% right over there. Sometimes that's very difficult to see. Because sometimes you have a very introverted child and they consult with the child and the child doesn't give much data to the person interviewing. And then they look at non-verbal cues because what all they have is the child will be sitting now in the room and dad will come in. Now they see, the child runs to dad and jumps onto dad's back. That's something positive. But the social workers are looking at these things. Or dad comes into the room and the child just stands up and just hugs dad, but in a affectionate way. Maybe that's not the only. They look for next hours. Maybe that could be just the shyness of the child. You get different kids, but then they look at these specific things, and then when they look at certain aspects, which I picked up as well, the child throws the toy on the floor, naughty. But there's a specific room for these things, and then the parent will say, "Johnny, please pick it up." And they look at that. Do you have the capability of actually, Or now Johnny starts crying. Can daddy pacify Johnny? Because this is dad's time alone with Johnny. Mommy's in a different room or mommy's at home. And they look at these specific things. Now they bring mom into the picture. How does mom deal with Johnny under these circumstances? And this is how the experts look at things. Draw a picture for me, Johnny. And Johnny's picture is there. This is it happens embarrassing here. Mom's new boyfriend and dad is not in the picture. And these things happen and they see we're the primary attachment. Or sometimes dad is in the picture. But all these specific cues they look at. They won't get involved. Sometimes a parent might give the child a bit smaller of a tap and they might say that's a very good thing because this is a naughty child and he requires that type of discipline. When mom gives in and mom just allows the child
to do
what
often the case.
Which is often the case has to do. But these are the mirage of issues to look at.
Here's one more question. My ex-husband wants to take the children overseas and as a mother, I have justified reasons why they should. What is the process that he should obtain permission from the High Court?
So I would imagine the mother saying she does not want him to go and she has good reasons for that.
Yeah.
So what the dad has to do is he will have to go to the High Court. Now, I am yet to see if it's a holiday and the children will not be negatively affected by that. For example, it's not a dangerous country like North Korea, for argument's sake, or war-zone countries and stuff like that. What often happens is, what I pick up is the father wants or the mother wants to take the kids to an Umrah, and that's very important. But sometimes what happens is the father himself does not have a very good connection with his kids. He only sees the kids most probably 1 or 2 hours per month. And then now all of a sudden says, I want to take my kids now overseas with me, but they don't overnight by him ever. So these are the dynamics we have to look at. But the long and the short of this specific answer, Christian, to answer it fairly, would be the father will ultimately have to go to court. And he has to give very good reasons why he believes that this holiday will not negatively affect his kids. And they will actually enjoy it and it will be good for them and they can benefit from that. The mother, on the other hand, will have to give very good reasons for the opposite. She must say it will not be in the kid's best interest. They're writing exams. Shazia doesn't know the dad so well. Naima doesn't want to be with dad. Naima doesn't like the stepmother. It will be more traumatic for them. They're crying. They don't want to go there. So these are all the circumstances that the court will have to look at. And the court will determine, is it best for the kids to actually go on holiday? And for how long as well? Sometimes dad wants to take them for a whole month, maybe 2 or 3 weeks. So all these factors must be looked at, and the court will have to make a decision on it.
Okay. Just on a final note, what practical advice would you give to separated or divorced parents who want to protect their children's well-being and also while they're navigating legal disputes as well?
Now, this advice I'm giving to the listeners now is advice I won't generally get from anybody else. My advice is fight for your child and fight for your rights. It's very, very important. Do not expect that the family advocate's office, the social workers, or the magistrate or the judge is on your side. Do not expect that to be the case. They must do their job. You must be your own mouthpiece. Don't go into these consultations and these meetings with keeping your mouth closed and expecting and crying there and expecting people to feel sorry for you. No. You need to toughen up, put on your big pair of socks and fight your case. That's very important. And I promise you, the results you'll obtain for fighting for yourself and standing up for yourself and giving your best shot is much better than it would have been had you taken the victim mentality, which I see it quite often. Take control of your case. And I'll be honest with you, I'm in this game very long, and I've been up against people who are underrepresented, but they put up a very good fight. Better than if they had to instruct their own advocate or attorney, because they fought for their rights. Maybe they never understood the law so well, but the passion was there. So in conclusion, fight for your rights.
Many thanks to our guest in studio, Advocate Mohammed Abduroaf, Advocate of the High Court of South Africa and also family law expert, for helping us better understand parental rights and also responsibilities after separation and divorce. And so while relationships may end, the responsibility to act in the best interest of the children remains. So by understanding the law and prioritizing the needs of our children, parents can build healthier co-parenting relationships and also provide stability during times of change.